So today we are going to see the first part of IPR as far as your syllabus is concerned, which talks about intellectual property. Now, what is the importance of IPR? We have spoken about it a bit yesterday, but you may get a question in your paper saying, explain the meaning and discuss the importance of intellectual property rights. So you can cover these points in that answer. One, you should be able to write that intellectual property rights refers to legal rights. Now, these are not some kind of rights that you get by default. You have to put in a registration, you have to put in an application for the same, and then get your IP registered, and then you're protected. So, it should definitely mean or say that it's a legal right which is granted to the creators, inventors and businesses over their creations, innovations and brands. Now, why we are talking about creations, brands and innovations separately? Because we have different IP rights for different categories. So for brands, like we saw yesterday, there is trademarks, there is copyrights for literature and those kind of creations, say music, etc. And innovations, you will get patents. So that's the reason why these words are very important. As we do a Google search using keywords, your answers should also have these kind of keywords to get better marks in your exams. So please define or explain what intellectual property rights actually means, and it also should include that it refers to legal rights that a person can get. So these rights, how do they work? So they allow the owners to protect their work, of course, one, from copying, getting copied, so that no other person can claim it to be their own. And thirdly, there has to be some kind of credit that should be given to the innovator or the creator of that whatever thing that is. So no unauthorized use will be allowed once you are protected. That's the reason why IPR is important. Obviously, as we spoke about some business, branding, and financial benefits yesterday, it also should earn a recognition. It's not only about the business, but it's also about your brand reputation, brand recognition. So, IPR helps you in protecting your identity. So I've enlisted the examples. Examples means patents, copyrights, trademarks, industrial designs that we saw yesterday. There's something called as trade secrets as well. And all these are a part of IPR. Now, when we talk about intellectual property rights, yesterday somebody asked me what are the advantages and disadvantages. Today we are going to talk about that as well. So what is the importance of getting an IPR? One is it is your protection of your own innovation. So any invention or innovation that you've done, you have put in a lot of hard work, you've done a lot of research, and trust me, R&D is not easy. Even though if you're writing a research paper, it constitutes a lot of, say, reading a lot of magazines, articles, white papers, etc. So just imagine if you're making a new product, that will ensue so much of hard work, and that hard work, that innovation has to be protected. So that is first thing, is protection of your own innovation, your ideas, the technology or the process that you've used in making that product, or the artistic works, whatever that could be. It could be a creation, not only a product but any other literary or musical creation as well. We saw paintings is also covered under this. So in general, IPR constitutes of all these kind of materials, and that has to be protected because it is your own idea and it is distinguished from some other things that are available in the market. Another one is encouragement of creativity. As I mentioned, the person who is creating the IPR, whatever the product or the artistic musical creation, you should get recognition. If your name doesn't come over there, then what's the use? There are many people you might have seen who are these kind of artists and painters and all. They want recognition more than money. They want people to know that they have created something beautiful, something different, something that distinguishes from other creations. So encouragement, of course, is very important so that you keep going. And obviously, third is economic growth. It gives you a lot of money. Now, say for example, as I talked about royalty yesterday, your music, even if you play or even if you use songs of say which are recorded in the 60s, the singers, the people who are involved in creating that song, even today they get royalty. So that's the kind of economic or financial benefit that the person can reap, and that is the reason basically why a person should protect his or her own creation through intellectual property rights. Fourth is global competitiveness. Why have I put the answer in pointers is because this is the way you should present your answer in the question in the exam that you attempt. One, because if you go on writing, there will be no justification as to what you want to express. And secondly, you should always distinguish your points one from another. So you should be able to explain your answers in such a way that if you say, for example, write point number 4, global competitiveness, and then write a paragraph on that explaining what and how IPR helps in managing or getting this global competitiveness, then that will be a better thing to do in your answer sheets. So I've jotted down the points. Likewise, you can take it from here as well. So what happens in global competitiveness is once you have an IPR, you have distinguished yourself from the other brands, from the other products in the market. So it's not only in India, but all over the country, say all over the country and plus all over the world. So there are many Indian brands which are going abroad. You might have heard about Reddy's pharmaceutical products, that is medicines and all. They market their products in other countries as well. So people know it as Reddy's. But is it that famous in India? We may know, we may not know. But all over the world, they have quite some reach, and it is different, distinguished from other medicines or medical products that are there in the market in those countries. So what happens is the product or the brand gets cutting edge, and it has separated itself from other brands which exist in that place as well. So it makes you globally competitive as far as your product is concerned. It gives you a competitive edge to the other products in the global market. Other point you can explain is consumer confidence. Obviously, once you protect your product with or your brand with an IPR, you are giving that kind of authenticity or that kind of quality, that promise to the consumer that the product and the quality of the product will remain the same over the years. Now, you might have heard we have been eating Cadbury since ages, but you might have heard about all those news where the chocolates were bad, there were some worms found in that chocolate. So what happened is the brand and the brand image got harmed at that point in time. But if there is some product which is IP protected, then that means that you are promising the consumers or the people who are going to buy your product that level of quality will be maintained and that will never go down. So you are earning their trust, and that is why it is called consumer confidence, or you're building trust with your consumers. What will happen because of that is, one, they will again and again and again buy your product. Only buying once means that you will have to reach to a lot of more consumers than your existing consumers. But if you see, as a business person, you would want the person to get involved in repetitive purchase of your products. Only then will you grow. How many people, say 10 people you have sold off your product to? You want to reach to 100, but those 100, if they keep buying again and again, then you will gain more profits, more benefits. So that's how happens only when you build that level of trust or confidence with the consumers, saying that each time I buy this product, I'm happy. I know that it is going to help me in some or the other way, maybe. Or if it is a food item, then you can say the taste never changes. So you prefer certain kind of a product. Say for example, you prefer Lay's chips over other chips. Why? Because you like the taste. So you are a repeat purchaser, and that's how the trust or the confidence remains with the consumer, and the brand builds its own identity and it grows. So that is consumer confidence. And knowledge sharing, obviously, after your innovations and inventions are protected by IPR, especially in patent. After getting patent, which exists for 20 long years, it becomes a public information. So it's there out in the public domain, and everything is known to the public as far as the product, the process is concerned. So it leads to knowledge sharing. That is what people believe. You're sharing your own technology, your research, all that hard work that you poured in. You have earned a lot in your 20 years, and then you are sharing it with people for their own benefit. Now, for example, if you see, patents are taken mostly in medicine, medical field. So what happens is 20 years you are earning that, say, premium on the medicine that you have created. But after 20 years, when it comes in the public, even others will get benefited, and those medicines will heal other people as well, who are not like they are not able to take your medicines. Maybe they are from some other country. So the best example is Covaxin, COVID thing that we created, as India was the first one to create that COVID vaccine. But at that point in time, if you have read, we never went for taking patent for it. And why? Because as you know, India is a very kind and humble country. We believe that if we take patent for the product, for the vaccine, then it will be not shared with the public or the world for 20 long years. And at that point in time, we all in the world were desperate to have a vaccine. There could have been many more deaths. We couldn't have kept it to ourselves. So what we did is we never filed a patent for that, and we shared that knowledge with people freely. We gave vaccines, we sold off vaccines so that other people could also protect themselves from the disaster and death. So that's the power of IPR. Especially in this case, I was talking about patent. So what are the advantages? As I mentioned, I have earlier, I have noted down some advantages and disadvantages as far as IPR is concerned. One is it encourages innovation. Obviously, when you are getting recognition, you're getting more money, you want to invent, you want to do research. Otherwise, what happens is, trust me, research is a very slow and a long process. It's not that we have done something today and tomorrow we'll get results. No, they go through a lot of tests, they get results, they wait for the results, and it really takes time. It's very tiring and hectic job. So nobody will do these kind of things unless they get money, unless they get recognition, unless they are getting some benefit out of it. So encourages innovation just means that it's an incentive for the person who is creating it. You should always be enthusiastic, you should always be happy and wanting to do something new. That feeling or that urge to do something new and create something new is developed, or it's kept alive when you get an IPR. You say, okay, I got a recognition, wow. So that is what is all about encouraging innovation. IP is the greatest advantage, is this, that you get recognition. Second is economic growth. As we were talking about business and attracting investments, obviously if your business is growing, there's a lot of job creation. So there's a lot of economics that goes into it, and in totality there will be economic growth of the country, of the sector, of your business, and that's a lot of growth. As we mentioned earlier, recognition and reward. So the creators and investors. Now, why we talking about rewards? Because as I mentioned, all those who are not business minded, I mean patent, medicine, or pharma companies, all who are doing business, they want more of patent, or they want to file patents so that they can sell off their medicines at a premium rate. But if you look at somebody who's involved in musical creation, who's involved in paintings, who's involved in literature, they all want their names to be known. They all want that kind of recognition. So you might have heard that some person has won this literary award. That kind of a recognition they want. They want to know, they want people to know that they are doing something or writing something beautiful, or they are painting something very nice. So rewards and recognition is very important as far as IP or the creation in itself is concerned. And that's the advantage of IPR. Other point is promotes fair competition, because nobody will be able to steal from one another, and we are stopping something from happening which is absolutely illegal in nature. Otherwise, in business, maybe some ideas are stolen, some processes are stolen, maybe some process that gives you quick result, or the product is a better product, functions in a better manner, or it is something that gives you better results. So what happens is, even saving time during production or manufacture saves a lot of costs for the business. So if you are developing such kind of a process or such kind of a result, then it's going to give you benefit. And if this is overnight, say, stolen by somebody and does the same thing, you may just not be able to have that competitive edge that you had as being a faster producer or something like that. So IPR protects you from all these kind of illegal activities, or not to put it as illegal, but some kind of things that are not right. And it promotes fair competition. So you do your business, I do my business, and we work the way we want to do. So it's all about creation of human mind, and we are stopping something that is unfair. That is the essence of promoting fair competition. Now, it fosters knowledge sharing. How? As we spoke about patents, after 20 years, it will be in public domain. All the information, all the facts, the tests, the results, the creation, the innovation, everything will be in the public. And many other businesses can take it and make products. Say, for example, I don't have a strong R&D facility with me, but I'm just, maybe someone's patent is ending, I may just take the formula and I may create medicines out of it. I won't be able to charge a premium, but at least I'm going on with the business. So there are many people in the world or in the country as well who are doing these kind of things. Of course, please remember, we are not talking about generic medicines here. Generic medicines is totally a different concept, but here we are talking about people creating products or brands or a certain kind of creations wherein the term of the IP has ended. Now, here in knowledge sharing point, it is mostly patents, because patent is not renewable and others are renewable. Trademark, copyright, etc. Whereas the basic difference between patent and others is this, that patent is not renewable. After 20 years, the information will come in public domain, and that will share, it will be shared, or rather it will be like it is shared with the public, and they will also know what is the product about and how does it function, how helpful is it. So it fosters knowledge sharing. Next is global trade opportunities. Obviously there are certain rules and regulations, there are certain international trades and collaborations could be done, and that's how you can maybe make yourself, your presence felt in the global arena. You can make money out of it. Trust me, there are so many countries. We say, oh, US and UK has amazing products, but there could be some African countries and some other small countries who say, oh, Indian products are better, because we are somehow maybe better than them, or we have better minds, we have better results out of the products. So global trade opportunities always exists. That exchange of information happens every now and then, and people are trying to develop and have better products. Now, why are we talking about better products or better creations? Because we want an easy life. Earlier, in earlier days, there were no phones at all. Then came a normal telephone, the landlines. Then came mobiles. Now we have smartphones. Just imagine somebody who's been of that age, wherein there was no phone at all. The person would have been amazed to see a smartphone. Just that one touch, you have the whole world in your hand. So that kind of technology or advancement we are talking about. People used to travel days to go and meet some relative or maybe someone whom they want to talk to. But these days we just quickly do a video call, which is so easy, simple, and quick. And that's the kind of development that we are talking about and we are living in. So trade opportunities always exists where somebody is maybe having a better technology, somebody is having a better product. For example, you might not be aware that except for India, I don't think anybody uses a pressure cooker. Now you would say, what is so different or important about pressure cooker? Everybody has it at home here. But if you go and see in countries like Australia, people don't know the concept of a pressure cooker. You don't get it in the market. So they may feel, wow, this is a best product that we have. We can just cook rice in maybe few minutes or something. So that's the kind of, exchange of ideas or information that we are talking about. In 21st century, people would not believe that somebody doesn't have something so basic like a pressure cooker at home, but that is true even today. So that's the kind of trade opportunity that we are talking about. And next one is protects cultural heritage. Now, how do you protect your cultural heritage? You can always have copyright of the like India, the country has to take initiative. Basically, there are certain traditional things or knowledge, like we have Ayurveda, we have simply to say, somebody at your home would say you are not well, you have turmeric milk. If you see in cafes, you get turmeric latte. What's the difference? It's the same thing. But we talk it since ages. So it's something that is cultural or rather traditional knowledge to us as Indians. But people in the world don't know. That's the kind of, you know, heritage or the cultural knowledge or the traditional knowledge that we are talking about. Therefore, it also includes folklore. So there are these songs, dances, music, which is very specific to say Rajasthan. You might have heard that there was some fest. There is a camel fest in Rajasthan, which is very unique to the culture and the place. So what happens is these kind of things are actually cultural heritage. Our forts, we have so many temples in our country. Other countries also have their own stuff. So what IPR does is it protects all this cultural heritage from getting stolen. Somebody may just take a pick and say, no, this is not, this is something that was created by some person from our place. And these kind of things keep happening. So that's how IPR protects this heritage and traditional knowledge. Now we have spoken about advantages a lot. Let's see what are the disadvantages. Yesterday somebody was concerned about this coming in your examination paper. Please take a note of these disadvantages as well, so that in case you have the question, you can attempt it. One is access to knowledge. Now what happens is when you are developing some new product, this is again pertaining to patent mostly, because patent is something which is not renewable, we spoke about. And next other thing is that once it is in public domain, it is out there. But then if you can't earn money out of it. So once you have an IPR, you enjoy it. After that, you cannot. So IPR actually limits your access to the critical knowledge or the technology that you have used. So of course, R&D is a huge cost, and after that you are not able to get anything out of it. So that creates barriers. Other point is monopolies. When you have certain things like these, you might have seen that certain, again, medicines, as far as patents is concerned, is very costly, and not everybody is able to afford it. So what happens, that person has to rely on some other medicines which comes at a cheaper rate, but may not give you that kind of effect. The person is not getting healed. So the problem here is that the brand or the product has created a monopoly for themselves. Now, if you want that kind of result, you have to buy that. If you don't buy it, you don't get those results. That kind of a monopoly. Now, monopoly is one of the basic and most important barriers to fair competition, fair trade, use of policies and competition. So monopoly is not something that anybody desires. in the business or business arena. Other point is innovation stifling. Now, what does that mean? Once you take a patent, that means it's a closed case. You don't have anything to know from that, and that means that you cannot really get any information, or you cannot do any research. Say, for example, you and me are doing research on the same topic, and you go ahead, get some result, you apply for a patent, and you get the patent. So, my research has gone to drains. It's of no use. All those years, all those efforts that I put in, I won't be able to claim anything out of it. So that's what happens, and that really discourages a person from doing further innovation or research. That's the problem, not only with the person who is doing the research, but the business who's attached to, or rather relying upon that kind of innovation or certain kind of information, or making a better product and wanting to make business out of it. So yes, high costs. R&D is a high cost. So small business groups or small little businesses, individual creators won't be able to afford high costs of doing certain thing, and they won't be able to get that IP protection. So that's one basic problem here, and there could be IP infringement, which again becomes a problem because legal battles are costly and that not everybody is able to afford. Other is a cultural concern. So, where IPR might prioritize corporate interests over traditional knowledge, but it leads to issues of misappropriation or exploitation. What does that mean is that it may give benefit to the corporate people, but what about individual creators? Whether their cultural heritage, the cultural knowledge is getting protected. Say, for example, I go out there and sell a Warli painting, but whether I will be able to get an IPR in that, even if I get it, whether it will remain or whether it will be subjected to some kind of exploitation. People will say, ah, Warli painting is very famous. It's just out there. It's not your creation. Maybe I've done something else, a little bit of change or some creation within it, but that may go unrecognized. So that's another problem. And of course, global disparities, where strong IPR enforcement in developed countries might not align with the needs or capabilities of developing nations. So what happens is where such kind of fights, or on the global arena there is certain dispute. So these developed countries always have been having a high handedness over developing countries. So that again becomes a major problem as far as IPR is concerned. So here we come to the next topic, that is patents. It's a little long topic, but we'll see what patent and how it is. So patent is granted to any product which is an innovation or an invention. And is it just the product? No, it could be the process as well. So the process of making the product can also be a better, shorter, and it could yield better results. And that's how you get a patent even for the process. Now, what are the characteristics? One, exclusivity. Of course, your product has to be unique, as we spoke about yesterday, it being unique, exclusive, distinguished from others. If it is nothing new, you will not get a patent. So characteristic of a patent is mainly invention or innovation. The word itself means new. So exclusivity is one. Other is territorial nature. Again, here there are different countries involved. So if you file for patent in India, you file for patent in Switzerland, you get it for that country or the countries that can be covered under that patent. If you file, say for example, you file in India, you get it only for India. Maybe Switzerland has a pact wherein it covers 1, 2, 3 nations, so you will get patent only for those three. So as far as your business is concerned, say for example, we have made a vaccine for some disease and we want to market it all over the world, we won't be able to, because our patent exists for the country where we have filed, or the countries were attached to the country where we have filed. So territorial nature really restricts you from making or doing business outside that territory. Other one is novelty. exclusivity, uniqueness, that's how novelty also comes in picture, where it has to be new or original. You can't say, you can't just copy from somebody else and say this is mine. There have been n number of cases where people have just copied someone's material or product or the process, and they've just twisted it in some manner and said this is unique and new and this is what I've made or we have made. So no, one, novelty is very important while granting patent. That's one of the basic and most important characteristics as far as patent is concerned. Fourth is utility. Now, if you've made some product which is not going to help you in the manner it has to be. Say for example, there's a scissor. The work of a scissor is to cut. If it is not able to cut properly, that means the usability of the product or the utility of the product is not as per what it should do. So the invention will not be helpful if the invention is not being useful, it is not being able to put to a practical use, then it's of no use. You will have to make a product which can be used in a practical manner, and it should do the work that it is supposed to, or whatever you're claiming it to do. So that's most important thing as far as patent is concerned. You will get patent only in such conditions. That's what it means. Non-obvious. Now, something that is known to everybody. Say a farmer will say, yes, sowing seeds and putting some water on it is an obvious farming technique. What is new in it? So, if it is something which is obvious, you won't get a patent. If you want a patent, it has to be non-obvious. It has to be something which is not any person from that area who is skilled or who is working in that area knows about. This is something, oh, it is so obvious. It can't be like that. Other one is time limited protection. Of course, as I mentioned earlier, you get it only for 20 years from the date of filing and you cannot renew it. So that's the only time limit, only 20 years you get to reap the benefits of what hard work you've put in, all the R&D that you've done. Disclosure requirement simply means that the patent applicant has to disclose everything, right from how the product came into picture, what process you use, what tests you've done, what results you've got. Everything has to be given. Unless that is done, the procedure for application of patent itself is not complete. So disclosure requirement also means that you may be letting out of some of your information, which is your, say, business secret or something. Unless you want to put it out there on the public arena, you won't file a patent. So that's the basic one of the drawbacks, you can say, as far as patent is concerned. Transferability, patent rights can be licensed or sold. It depends. Once you get the patent, you can do whatever with it. So you can just license it to some other person. Say, I have created some medicine and it's a new medicine and I have taken patent for it. So I can just license it to someone for manufacturing the medicines. I don't have to have a manufacturing facility and, make medicines out of it. I've just done the R&D. I am a scientist and I have made the medicine. That's all that I am doing. But I have taken a patent and I will give it to someone else to use it further. You can also sell it off. Like there are many people who just do the research. They have a research facility. They have that kind of expertise, maybe people around them employed, and they are doing that research and they will just sell it off to, say, some big pharma company. I'm saying now this may give you, say, $200 million. So I'm selling it off at that price, and then they can market, because just manufacturing the medicine is not the only thing that is to be done. You have to market it, you have to sell it, you have to distribute it, which is like a big thing. And if you don't have that kind of a capacity, then you can just sell it off to somebody who can do it. So that doesn't stop you from really doing R&D. So as far as patent is concerned, you can transfer the rights for say manufacturing, for distribution, etc., to any other person, allowing the inventors to monetize their creation. Obviously, I'm not going to give it for free. I may charge whatever that I think it is worth. And invention specific. Now, patents apply specifically to inventions whether process, machines, compositions, or designs. It cannot be anything out of these categories. So it is very specific to inventions and innovations, as I mentioned earlier. Now, one of the most important, I think this is one of the favorite questions that the university likes, is my observation. If you go through your like past 10 years or 5 years question papers, you will see that you may get here and there in twisted words, but they ask what is the process of filing a patent, because it's a tedious job and it's a huge and a long process. So just for your sake of answers, I have jotted down it in points. You can take it down. One is determine patentability. So you have to actually assess it yourself, that whether your invention or your innovation is novel, which means new, non-obvious, that means nobody else knows it, and whether it is useful, because you have to put it to some use. And if it is, we saw in the point of utility, if there is no utility of the product, you can't really get patent. So determining patentability of your invention is very important. That should be done. It should not be publicly disclosed and should not be already patented. That means that there could be some other inventor, scientist who has already done the research, taken patent and disclosed it in public. Then how come you have, maybe you have done your own research, no wonder, but I am doing it in India. Say, for example, somebody in New Zealand has already been there and done it type, and they have already disclosed it in the public, they have already patented it. Maybe while doing research, I don't know, but after, I should be aware, because I won't get the patent if it is already public knowledge. So one, it should be patentable. To conduct a patent search, so you have to really go through all that process of researching, searching how, what and why of the patent related to your product. This helps to ensure that your invention is not getting infringed on existing patent. So if there is some other patent which is existing, say he's already, that product has completed already 10 years of patent, and somewhere around the corner you're saying this is, my innovation and this is my research, then it won't be of any use. So you have to do that kind of a search or a research to know where, and say for example in other countries or within the country, any other scientist, whether the person has done some research, whether he has come up with some product or some process, etc. Then you have to prepare documentation, which includes title, abstract, detailed description. Detailed description is an important part in this, because it should have all the technical details. So as I was mentioning, the process, the tests, the results, kind of days that you have taken to process the stuff, all those kind of things, all those technical details have to be mentioned. Claims and drawings for visual representations, you have to prepare a full document. So the scientist or the researcher or the innovator or the creator has to prepare a proper document which enlists all these details. Now, which type of patent do you want? So there are different patents: utility patent for new processes, machines, compositions; design patent for ornamental designs; plant patents for new varieties of plants. Now there are so many different types of new varieties of plants that have come in the market. If you know, you might have seen violet carrots, violet cabbage, something which is unique, something that is new. There was some kind of papaya, I remember reading it in news, which was small. It used to, the fruit used to come on shorter trees with lesser seeds. I think virtually now there are no seeds at all. So there are certain kinds of plant varieties, and why plant varieties? Because these fruits are going to come on those plants, right? So plant varieties have come up, and a lot of stuff in the market, if you see. So there are a lot of plant varieties that can also be patented. So you have to choose the right type of patent that you want to get. And lastly is filing the application. So you have done the application, you have written the title, enlisted all the results and technical details and everything. So you have to submit your application to your country's patent office. There is certain fees for filing. So you have to mention this in your answer. That's why I've mentioned it here, point wise. Next is paying fees. So whatever required filing fees, whatever that is, depends on the country and the type of patent that you're seeking. Other one is examination process. So the patent office will, after that all you have done, the patent office will see your application, read it, review it, and then it will say, for example, they have some doubts, they will get clarifications or modifications from you. Then there is something called as publication. So in many countries, the application is published after a certain period. In India, it is 18 months. And why are they publishing it? So as to see if there is somebody else who wants to raise objection. Now, patent office is not an expert in your field, right? So if somebody else who has already done the research or he's already taken patent, that kind of a patent, then he has that time limit to raise objections, to contact the office and say, hey, I already have a patent on this product which is so similar, or which is so, something which is maybe not even similar, maybe the same thing itself. So there is certain time limit wherein the person can raise objections. That's the crux why it is being published, so that others know that we are trying to get a patent for a certain product, and to ensure that there is no one else in the market or in the field who has the existing patent or has already done that kind of research. And lastly, granting patent after everything is done, all applications are reviewed, all your tests are seen that it is right, your results are right, then you get an approval and the patent office will grant you a patent, which provides you exclusive rights to your innovation or your invention. Wherein we spoke about what are those exclusive rights? Your right to sell, your right to say lease, license, etc. So that just exists with you and nobody else, because the patent is in your. So yesterday there was a request for case laws and I've enlisted some here. As far as patent infringement is concerned, you have some popular case laws here. Bajaj Auto versus TVS Motor Company. There was some permanent injunction granted against TVS, which highlights the importance of protecting patented innovation. There was some unauthorized use of the Bajaj patent, and there is some technology that they have developed by TVS Motor Company. So they sued them and they got a permanent injunction. Permanent injunction means that, simply means that they cannot use or further, market it as they were saying it to be. So they just have to shut their, or put a full stop to their operations in that field, or whatever that they were doing, manufacturing or marketing or whatever. Other more important is Novartis versus Cipla. As I was mentioning in patent, there are a lot of medical research that is involved, and medicines keep coming every time. Many of them are patented. If you pick any exclusive or say expensive medicine, you will find that it is expensive only because they've got a patent for it. So Novartis versus Cipla is one of such cases where there was patent infringement. Ericsson versus Xiaomi. Now we all know they are mobile phone manufacturers. So there was something where they were infringing their standard essential patents, and they got some license agreements, and patent technology was used. So suit was filed. F. Hoffman LaRoche versus Cipla is a very famous case wherein it relates to a cancer drug, and there was infringement of patent of this cancer drug. So we come to next topic, that is geographical indications. Now what is geographical indications? Anything that denotes products of a general specific geographical origin. So Assam tea, Swiss chocolates. So why this Assam and Swiss? Because they are different and unique, or rather unique to that place. So when you recognize a product with the place, then you call it as geographical indication or geographical indicators. So why is it different? Because it possesses qualities, reputation, or characteristics due to that origin. You have many teas in the market, but Assam tea will taste different. So someone might give you and then they might say, oh, this is an Assam tea. that kind of a reputation that is attached to the tea. It also, you also have another example of Darjeeling tea. So it is very unique to that place. That's the reason why geographical indicators come into picture. Now, what is the importance of geographical indicators? One, again, because all these are products which are there in the market, you might see that there could be these kind of products which are bought by people, and that's your consumer base. So consumers or customer base should have trust in you. You cannot just say Bombay chai. That doesn't make any sense, right? So that origin and the quality of that product is something that is unique to that product. That's the reason why geographical indicators are given as an IPR. So it assures consumers that it comes from that place, it is of that quality. So you know that this Assam tea is going to taste in particular manner. So that's how you make a choice over other products. And that's how you build consumer trust to build your business. Other is global recognition. Of course, when the product goes out of the country, then people will not say just say that this has come from India, but they will also say that this has, like for example, Ratnagiri Alfonsos from Ratnagiri. So people know that, oh yes, these Alfonso mangoes are the best. You will not get such mangoes even in other parts of India. They won't just say it's an Indian product. So that's the kind of, or the level of global recognition that you can enjoy. Of course, it prevents misuse, because there could be no other counterfeit goods or products which can claim to be that belonging to that place, because the person who's used the product knows how it looks, how it tastes, or how it is. So mostly there are these food products. We'll see some examples as well. Protection of regional identity. For example, Darjeeling tea or champagne is recognized for its geographical uniqueness. So it safeguards the unique identity. Now, why are we talking about this unique identity all over again? Because it talks about a lot about brand identity, the uniqueness of your brand, which leads to brand recognition. So this is all about business. And once your product goes out of the country, you don't charge something that you charge here within the country. Your price tag changes, right? So even if you see, say for example, you've got some Swiss chocolates, they may be charging some other price at their own place, but when it comes here, it becomes a premium chocolate. Why? Because it is belonging to that place. So it protects regional identity and economic value that we spoke about. It's all about reputation and marketability of the product. It is going to give you a higher income, same product, more price. That's what it is. And that's the reason why people take geographical indication as an IPR. They want to protect that product. And lastly, preservation of tradition. We spoke about traditional knowledge, practices, and techniques that have been handed down from generations, wherein I gave you an example of turmeric milk. So, geographical indicators could also have certain products which have this kind of a hue to it, tradition, which is traditional knowledge unique to a place. Now, I've enlisted examples for your benefit. If you are attempting any question related to geographical indicators, whatever the question may be, when you start off with your answer talking about what is geographical indicators, please write examples, because it is very beautiful and it is very unique in its own way as compared to patents, trademarks, and copyrights, wherein there are certain categories. You have actual examples here, so we'll see a few here. One, agricultural products. You have Darjeeling tea. I mentioned Assam tea, which is renowned for its flavor and aroma. There is basmati rice. It has got some unique fragrance. The grains are long. It cooks nicely, etc. Blue Mountain coffee, which is originally from Jamaica. It is known for its taste and grown in Blue Mountain region. So these are certain agricultural products. Next, Pashmina shawls, we all know, which is very unique to Kashmir. And people would say that there is no other shawl which can compete with Pashmina shawl. So it is very unique to that place. Murano glass, which is unique to Italy. It's unique glassware. And Kanchipuram silk saris, you might have heard. Kanchipuram is a place in Tamil Nadu which is having exquisite silk saris. And I think the kind of rate, the price tag that they actually put up for these saris is very good. So they earn a lot of money out of this only by attaching its name as Kanchipuram. And when a person goes to buy it, the person knows that it is some kind of unique and good quality silk that is originated from this place. That's the reason why GI is important. Next one is food and beverage. You can categorize your examples in such a way so that it looks neat and clean on your answer sheets, and also it reflects the person who's checking your paper will come to know that you have done good research or have actually tried to understand the concept well when you enlist such good examples. Food and beverage, one is champagne, which is very much unique to France. Parma ham, which is again Italy. This is some kind of dry cured ham from place called Parma. And Roquefort cheese, which is again unique to France, which is a blue cheese and which is made from sheep's milk. So, these kind of uniqueness to the product is something that people like. And now tomorrow I cannot come up with some cheese and say this is Roquefort cheese, right? Because it may not taste as it tastes, the original tastes. So that's how GI helps in protecting your uniqueness, preserving your brand identity, and helps in expanding business. I've put some case laws here. Coded Distilleries versus Scotch Whisky Association, wherein importance of protecting GIs was emphasized to prevent misuse and ensure authenticity. Because once you attach a place's name, it just means to the consumer that it is very authentic. So that's important. Other one is Basmati Growers versus Agriculture and Processed Food Products Export Development Authority, where the case highlighted significance of adhering to GI registration rules and protecting reputation of regional products. Because just remember that all these products are very regional because they originate from a certain place. Tirupati Laddu controversy, you might have read about it in the newspapers. This case explored the boundaries of GI, whether and how much the scope of geographical indicators exists as far as any product is concerned. Another one is Bangla Rasgulla versus Odisha Rasgulla. Now, there was this big fight over Rasgulla when they went for GI registration, and the case underscored the cultural and economic importance of GIs. So, we have come to the last slide. I would like to show a few slides from the last session. I have enlisted case laws for copyright and trademark. So there are these some popular cases for copyright infringement versus RG Anand versus Deluxe Films. This is a very old case, 1978, where the Supreme Court of India ruled that ideas are not protected under copyright, only their expression. So the substance or essence test, there is this test which was introduced to determine infringement. Now, what is the scope of copyright? What is infringement? That's what came up from this case. Other one is Eastern Book Company versus DP Modak, which is 2008 case. The court addressed whether legal texts could be copyrighted. It ruled that while judgments are public domain, editorial inputs like headnotes and formatting qualify for copyright protection due to their creativity. So someone who's writing, say, a comparison, some headnotes or some criticisms over it, that is a creation of the mind of the person, and that can be protected, but the judgments cannot. Indian Performing Rights Society versus Eastern India Motion Pictures, which is a 1977 case. It clarified that once a musical work is incorporated into a film, the producer becomes the first owner of the copyright. And there was this specific case where the question was whether the producer is the first owner of the copyright or the society or the association, because whose creation is it? So it basically deliberated over Section 17 of Copyright Act. Next is Superfast Industries versus Entertainment Network, which is a 2008 case held in Delhi High Court. It ruled on broadcasting copyrighted songs on FM radio without permission. So it emphasized the importance of obtaining licenses for public performance. You might have heard that these singers go abroad, they go to various states, they sing songs. You have foreign nationals who are singers who come here, and somebody from the international music arena who comes here and performs songs. So what if he is not singing his own song, his own creation, but someone else's creation? So is it not the infringement of copyright? That's something that was highlighted or focused upon in this case. Another one is Star India versus Movies Trunk. So this Star India sought to prevent unauthorized streaming of films, and the court reinforced the need to protect copyrighted content from online piracy. We all know that even before the movie comes in the theater, there is a pirated copy that is available on various websites. Maybe not these days, some places, some movies are released, and what happens is that one, the copyright is infringed, and because of that, basically, see, as a common man, we don't understand, or we don't want to even know whether there is a copyright and it is getting infringed. But the problem is the creation, the creator, or the producer, say, of the film, his business is going to get affected adversely. And why has he taken all the pains to take copyright? So that he can protect it from such piracy or getting copied. Okay, so yesterday we had a slide on case laws, which was actually a trademarks case law slide. So I'll just run through. So these are recent case laws which were related to trademark. Make My Trip versus Google. We spoke about it yesterday, and there is certain internal trademark infringement as far as Google and Make My Trip was concerned. Now, here the court ruled that users booking tickets through MMT wouldn't confuse it with booking.com. There's this booking.com which is probably owned by Google, and that's how the it went to Supreme Court, and there was a big fight over it, because obviously, see, at the end of the day, the business is getting affected under the pretext of somebody's name. You are running your business, and the person who is purchasing it thinks that it is that person's product, and he's getting fooled. So, where you say that you're fooling a person and getting the business, getting the money, it's a completely unfair kind of a practice that is done in the business world. So, one, obviously, they had trademark in place. If there was no trademark, then maybe it could be just used freely. But there was trademark, so we spoke about trademark infringement, and that's how Supreme Court ruled that there has to be some sense in using and not confusing the consumers. Other one is Motimel versus ex-franchisee. Again, this is a Delhi High Court case which granted interim protection. And last one is IKEA versus I, which is a trademark infringement case once again. Okay, so till people make up their mind to ask any question, there was one question that came up yesterday which spoke about the term, and I think there was some confusion. So let me clarify that today. Patent is for 20 years and then it becomes public information. It is not renewable. Trademark is for 10 years, but it is renewable at the instance of application being submitted by the creator to the trademark office. So that's the reason why the unique feature of trademark is that it has perpetual life, because even though it is granted for 10 years, you can renew it again and again and again. But obviously after 10 years or before the end of 10 years. Third is copyright. There was a huge confusion here, and copyright is granted in various categories. Now, one, it actually talks about sections 22 to 25, 26 of Copyrights Act. If you can see, section 22 talks about copyright for published literary, dramatic, musical, and artistic work which exists for the life of the author, that means till the death of the author, plus 60 years. That is after his death. So there was somebody who asked me yesterday whether it can be passed on to the next generation. Of course, yes. The answer is yes. Other category is section 23 of Copyrights Act, which talks about anonymous and pseudonymous creations. Anonymous is where we don't know who the author is. We are not aware the name of the author. We don't know who's written it. And pseudonymous is fake names. So say, for example, I write articles in the name of some other name, AB, for example. So that's a pseudonym. That's not my real name. So in this case, it is 60 years flat from the date of publication. We don't know the author. So we don't know when the person has died or when, till the life of the person plus 60 cannot exist because we don't know who's the person. So it is only 60 years from the date of publication. Section 24 talks about posthumous work. Posthumous means after the death of the person. So when it is published after the death of the person, and that's the reason why it is 60 years from publication, which is obviously after the death of the person or the author. Section 25 talks about photographs, which is 60 years after the death. So after the death means that it exists for the life of the person plus 60 years after the death of the creator. Next, it talks about cinematograph, which is 60 years from publication. All others exist actually only for 60 years from publication. Cinematograph, sound recording, and government works. All are these kind of creations which are only for 60 years from publication, and they do not include this life of the person. Basically, wherever author is concerned or author comes into picture, which is literature, basically literature, drama, music, and arts, there the life of the author plus 60 exists. Otherwise, you can just blindly remember that all other categories is 60 years from the date of publication. So I hope you're clear with the term of copyright today.
Thank you so much, Sumedha, and hope to have you for more practical oriented
Yes,
sessions in the near
definitely.
future. We
Thank you
missed
so
you.
much, Malvika and team, and thank you, PLEA, for inviting me. Okay, thank you so much.